On the 26th of January of 2022, the Supreme Court handed down judgment in a case concerning the statutory offence of wearing, carrying or displaying an article showing support for a proscribed organisation. And it raised the questions whether that offence is one of strict liability, and if so, whether it's compatible with the European Convention on Human Rights. The judgment is reported at 2022 1 Weeklies 789. The background was that in 2001 the Kurdistan Workers' Party, or PKK, was proscribed by the United Kingdom as a terrorist organisation. It's also defined as a terrorist group by the European Union, the United States, the Netherlands, Spain, Austria, Germany, Canada, Australia, New Zealand, and perhaps less surprisingly, by Turkey. On the 27th of January of 2018, the three appellants in this case took part in a demonstration in central London against the actions of the Turkish state. The rally began outside the BBC at Langham Place, and there was then a march down Regent Street to Piccadilly Circus and onto Whitehall, where the protest continued outside Downing Street. In the ensuing criminal proceedings, evidence was given by an expert from the Royal United Services Institute to the effect that the flags carried by each of the three appellants had been adopted by the PKK in 2005, that the vast majority of observers of a Turkish or Kurdish background, especially those politically aware enough to be at a rally of this sort, would have recognised these as PKK flags, that given the plethora of Kurdish political parties with three-letter acronyms, they tend to make themselves more readily identifiable by the symbols and the flags that they adopt, that being central to the expression of political loyalty within Kurdistan. And that demonstrators on this issue often choose not to fly flags, and even those who do are able to express their sympathy for the cause by flying flags which have not specifically been adopted by the PKK. As regards the specific actions of the three appellants in the course of the rally, the findings of fact made by the Crown Court included that they were each carrying their flag for more than 2 hours, unfurling them, holding them aloft, looking up at them and waving them, and that the first appellant specifically took a selfie of himself and made a V for Victory sign whilst carrying the flag. The Crown Court also held, and I quote, "The most natural and likely reason for a person to display a flag at a public rally is to demonstrate support for the organisation represented by that flag, and any objective, informed and reasonable bystander witnessing the conduct of the three defendants would have had a reasonable suspicion that he was a member or supporter of that organisation." End of quote. All three men were charged under Section 13, subsection 1 of the Terrorism Act of 2000, with carrying an article in such a way or in such circumstances as to arouse suspicion that he was a member or supporter of a proscribed organisation. They were convicted by the Magistrates' Court, and their appeals to the Crown Court were dismissed, as were their appeals by way of case stated to the Divisional Court. On their further appeal to the Supreme Court, the Justices set out the legislative framework on proscribed organisations, noting that the offences created by Section 11 on membership and Section 12 on support for such an organisation are both indictable, and at the relevant time carried a maximum sentence of 10 years imprisonment, subsequently increased to 14 years, whereas the offence under Section 13 is summary only, with a maximum term of 6 months imprisonment. On the issue of strict liability, the court referred to Sweet and Parsley, B. A. Minor and Director of Public Prosecutions, and the Crown and Chowdhury, and on the question of compatibility with the Convention to Perinsek and Switzerland and Alekina and Russia. The court then held as follows. Firstly, The section did require a limited mental element in that a defendant did have to know that he or she was wearing or carrying or displaying the article in question. Secondly, however, the statutory words context and purpose meant that the strong common law presumption in favour of a requirement of mens rea, or a guilty mind, was rebutted by necessary implication, with the consequence that this was a strict liability offence, with no extra mental element required over and above the defendant's knowledge that he was wearing, carrying or displaying the article in question. Thirdly, on the natural reading of these statutory words, it wasn't at all easy to see how one could know or intend that someone else would have a reasonable suspicion of something. Fourthly, if mens rea were required, Section 13 would be redundant, since the conduct necessary to give rise to the offence so defined will almost inevitably fall as well within Sections 11 or 12 on membership or support of a proscribed organisation. Fifth, the dual purposes of Section 13 were to avoid giving the oxygen of publicity to such organisations, and also to avoid the public disorder that might result from reactions against such displays of support. Neither of those purposes depending on any knowledge or intention on the part of a defendant that his actions would arouse a reasonable suspicion in an observer that he was a member or supporter of or intended to express support for a proscribed organisation. Sixth, the interference here with the right to freedom of expression was justified for convention purposes, since it was prescribed by law, being expressed in clear terms and with sufficient precision to enable an individual to foresee the legal consequences that a given action would entail. It pursued the legitimate aims of national security and the prevention of disorder, and it was necessary in a democratic society to achieve those aims and proportionate to them, striking as it did a fair balance between demonstrators on the one hand and the community at large on the other. Seventh and finally, the jurisprudence of the European Court of Human Rights did not contain any principle that a restriction on freedom of expression could only be justified where such expression included an incitement to violence. And so, for all those reasons, the court held that the offence in question was one of strict liability, but nonetheless compatible with the Convention, and the appeal was therefore dismissed.